I hereby open this academic ceremony in which Francesco Maletto will defend the academic thesis Enhancing Marine Protection, the Role of Prevention in Addressing Pollution from Land-Based Sources, starting from the European regional experience. Mr. Maletto, may I invite you to present a summary of your studies and conclusions of your thesis.
Dear Mr. Prorector, dear members of the committee, thank you very much for being here this morning. It's a true honor for me to be here today. Before starting to introduce my work, I would just like to take a moment to thank the assessment committee for dedicating time to review my work and for their precious comments, which I think were crucial to improve the quality of the work. And also, I would like to thank my supervisors, Professor Faure and De Vitor, for their continuous support during the research and for this wonderful opportunity. Before introducing my work under a legal standpoint, I think that a few factual information is necessary. As you might know, marine pollution from land-based sources is among the most serious threats to the preservation of the marine environment. According to UNEP, it's responsible for about 80% of total marine pollution. And this data actually struck me when I first approached the topic, because if you consider academic literature is a topic that, compared to other fancier environmental topics, is a bit neglected in academic literature. So that reminds us also of the importance of academic research to bring to the stage also other relevant environmental issues, for example, one like the one that I dedicate in my research to. If we were to summarize what marine pollution from land-based sources is, that's quite a difficult task, because you can, of course, think of multiple number of sources and inputs to the marine environment. We could, however, think of two types of inputs to the marine environment: points and diffuse sources, for example, point sources, discharges, and pipelines to the marine environment, or diffuse sources, for example, runoffs from nitrates, land from rivers, issues that derive from, for example, from agricultural farming, which are crucial also in a country like the Netherlands. And on the other hand, energy and contamination brought through the atmosphere to the marine environment. Despite the entity of this global issue, progress in tackling it has been quite uneven and not always consistent. The situation has improved with regard to certain contaminants, such as, for example, radioactive waste, hydrocarbons, persistent organic pollutants, while on others, for example, nutrients or plastics, the situation has significantly worsened. Nutrients runoff cause a situation called eutrophication, which is particularly relevant in enclosed seas, for example, the Baltic, which is virtually dead in terms of biodiversity because of the excessive inputs of nutrients to the marine environment. In parallel to these scientific issues, there are also relevant legal considerations due to the complexity of this source to regulate. So when I firstly approached the topic, the first question that I asked myself while reconstructing the legal framework was, is this legal framework, the legal framework in place at supranational level to address this issue, fit to effectively address it? And should the answer be negative, and I can anticipate that it was, I reflected on the existence within this legal framework of a general rule of international law that could be extracted and act as a common denominator to potentially offer an added value in tackling this issue. I have a bit anticipated the first research question, which regarded the reconstruction of this complex legal framework. And to do so, I analyzed the supranational layers of regulation, starting from the local to the global level, to regional regimes with a particular focus on Europe, and then to the EU law regime, to have the occasion also to analyze how the EU law regime interacts with the system of public international law. Anticipating the conclusion of the first research question, I can already say that the legal framework, which is quite vast and complex to reconstruct, is, however, fragmented and parceled and lacks, in general, overall coherence, which prevents this framework to exert an effective function in regulating the issue, especially for the lack of potential of powerful enforcement remedies. All the relevant layers present different features, of course, and different shortcomings. However, the conclusion I think can be common for their totality and conclude for the lack of effective potential. This led me to the central part of my research, which I called in an intermezzo in the research, where I reflected on whether this general, ineffective legal framework showed common elements that could be extracted and valorized to build and validate a general rule of customary international law. And in this regard, it was clear from the analysis on the first part of the research that the legal framework is informed by a general objective of preventing marine pollution from land-based sources. It looks like a specification of a general rule that obliges states to prevent marine pollution from land-based sources. This is why I tried to extract a general preventive rule from this legal framework and reflect on a potential added value in more effectively tackling this issue. And that is why I decided to test such the principle of prevention, which implies also a very clear prescriptive dimension that requires states to prevent environmental harm, in our case, to the marine environment through marine pollution from land-based sources. And through these assumptions, the second part of the research started. Before entering in the second research question, I should, however, present what will be the added value of such a rule of general international law. What is the added value that could be offered? In the analysis, I have explored at least 4 reasons that I considered relevant. First of all, we will have a rule of customary international law. As you know, customary international law binds all states, so that will, irrespective of treaty provisions applicable among states, will be valid for all states. And also, given the specific features of marine pollution from land-based sources, and also the growing tendency in the international legal orders to consider environmental issues common to mankind, this rule would have also an erga omnes application, meaning that any state will be entitled to react to a violation of this rule. Second point will be supplying to the traditional difficulty of the international legal order in achieving the conclusion of environmental agreements with ambitious and effective provisions. That is actually the main problem that we are also assisting in present times to. So, building on a general rule, any agreements that are of course always necessary, they will be specifications. They will put in operations rules that are already retrievable from the international legal order and stem from a parent rule already valid among them. The third point revolves around the concept of due diligence, which I think is crucial for the analysis. Due diligence, as you know, is a standard of conduct that states must stick to while complying with certain obligations of international law in this case. The due diligence, so the standard of conduct, comes to coincide with the legal framework that regulates marine pollution, and therefore, through acting as a sort of filter, as a revolving door, would allow provisions that in isolation are difficult to enforce to be enforced through a violation of their parent rule. Fourth point, in my opinion, will be guaranteeing the coherence of the whole system, supplying to gaps and lacunae of the international legal order, also in light of the most recent tendencies of the international legal order around the systemic integration of international law under Article 31 of the Vienna Convention on the Law of Treaties, but also, as most recently mentioned, as you know, in the 2024 advisory opinion of ITLOS on climate change and international law. This is why in the second part of the research, I reflected on the features of the principle of prevention with an implied rule to prevent marine pollution from land-based sources, a rule which is a framework rule, so which means that compliance with this rule can only be discharged by complying through sub-obligations that come through the applicable legal framework, a vast and fragmented legal framework that is brought to coherence through a framework rule and through the concept of due diligence that, as I said, allows to retrieve specific duties which come to constitute the content of the primary obligation requiring states to take all appropriate measures to tackle marine pollution from land-based sources. And concluding, in my conclusive chapter, also I tried to reflect on the practical potential of this rule. How could be this rule applied? Being myself a strategic litigator at an international LGO, I reflected on how I could use in practice this rule. And in this regard, I reflected on the various layers of regulation that I have analyzed. And at the moment, I think the most potential stage to practically apply such a rule will be national jurisdictions, especially jurisdictions like, for example, the Italian legal order, where customary international law is directly applicable and also endowed with an increased legal rank. For example, in Italy, the customary rules of international law have constitutional value, so that would exert a significant power. Also in environmental litigation through the input of environmental NGOs exerting their environmental democracy rights. And I think that there are also a few lines that should be that I touched upon in the final part of the research, and for which the contribution of the assessment committee was fundamental. And I think that, of course, being the PhD research not a finite work, I think they are useful inputs for further research. And I think of the potential of human rights litigation, which is, of course, acting as a new trend in intercepting environmental protection needs, the role of science, which has been regarded as crucial also lately by the ETLOS. However, it's a topic that should be handled with a very careful approach in order to avoid considering science as a dogma and balancing judicial review and full jurisdiction. And finally, the systemic integration of international law, again touched upon by the ETLOS lately, which I think confirms the approach that I followed in this research of reconstructing the content of primary obligations of international law through the international context, normative context in which these rules operate to tackle challenges of global relevance. Thank you very much.
Thank you so much, Mr. Maletto, for your presentation. The opposition now will be opened by Professor Peters. Professor Peters is Professor of Environmental Policy and Law, and she chaired the Assessment Committee. Professor Peters.
Thank you, Chair. Dear candidates, it's my pleasure to congratulate you with your research. In the book, you have provided a comprehensive analysis of the role of prevention and legal instruments concerning marine protection against land-based pollution. And for that, you discuss an impressive number of legal instruments established at international and EU level. The research, the thesis, aims to be innovative by analyzing the concept of a passe-partout rule. And in this sense, as you have explained, you wanted to discuss the added value of the principle of prevention, as explained in your research question 2. If I understand the approach correctly, the aim is to derive an overarching rule from a principle, which is indeed original. Meanwhile, environmental law keeps on developing, and within the European Union, already in 2019, I'm not sure whether that is the year that you already had started your research, but it's 5 years ago, the European Commission introduced in its Green Deal communication a new or perhaps existing principle called by the Commission the do no harm principle, which you indeed mentioned, but shortly in the final version of your PhD on page 226. The Commission proposed this as an overarching principle in order to align the different fields of environmental law. And by now, the principle has been concretized in binding rules. For instance, under the taxonomy regulation, which was adopted in June 2020. And this regulation aims to label investments as green. However, the threshold of do no harm has been lowered. Namely, it's now called in the binding law to do no significant harm. However, I could not find a critical analysis of how this codified and concretized approach relates to the principle of prevention in EU law, and I did not find that in your book. And now I have the opportunity to invite you to discuss this. So my question is, I wonder what, based on your doctrinal research, what are your initial thoughts about the EU having introduced already this principle in communication, but now also codified in a regulation? Is this, in your view, equal to the principle of prevention? So is this, under a different terminology, actually what the principle of prevention is? Moreover, the taxonomy regulation has codified it in order to provide overarching protection, so connecting the different fields of law. And importantly, one of the objectives is the sustainable use and protection of water and marine resource. So basically, is your wish that you wanted to, the aim of your research and hence also your wish, already fulfilled by the EU legislator? And I would like to add to that, because I reread this morning part of your research, that with such a regulation it's directly applicable to private actors. So the research is very much also about obligations for states, but here we already see binding law with to do no significant harm, and then applicable to the market, to private actors. I'm looking forward to your thoughts on this matter. Thank you very much.
Highly esteemed opponent, thank you very much for your question. I think this is a very interesting question. Indeed, as it was also pointed out in the reviews, the EU law system is very interesting with regard to the approach to the principle of prevention, which in a way has been able to achieve not much in the European legal order, especially in my opinion because of the way it has been treated by the Court of Justice of the European Union in its case law, which is quite limited and merely considers the principles included in Article 191 of the Treaty on the Functioning of the European Union, mere guidelines for the legislator, but not something that can be scrutinized and not to assess the lawfulness of an act of the European institutions. While reading the instruments of the the Green Deal and also the introduction of the no-harm principles in these policy instruments about from the Union, I had the feeling that they operate in parallel to the principle of prevention as enshrined in the treaties. The principle of prevention is there, and it's a bit underused, in my opinion, while we have these policy instruments with a different legal value, because in the end they're enshrined basically in communications of the Commission, but have no binding force, such as, on the other end, Article 191. And we are actually assisting, especially in the most recent years, to an approach of the European Union which, despite the proclaims included, for example, in the Green Deal, significantly waters down ambitious legislation. We can see that, for example, from the EU NATO Restoration Regulation, which from a very ambitious project at the beginning, now the text which hopefully was adopted is not as ambitious as it was. So I do not consider this principle, the principles proclaimed in these policy instruments as equal to the principle of prevention, because they're not endowed with the same legal force as. So.
If I may, thank you so much. But if I may, but now we have seen a concretization in a regulation which is binding. So I fully agree that if it only stays with codification in the treaty, and you refer to the limited testing by the courts, but now we have this development that we have a concretization of do no significant harm in a binding law. So to what extent should this be welcomed? So is there some positive news, or what is the critical analysis to the fact that it is now concretized and binding law?
what I consider criticizable in a way is that the ambition of the principle is a bit watered down compared to the original ambition, and I think that's exactly the aim of my work, is to provide a rule that could be applicable in states to have a gap-filling function.
I understand. But finally, very short and briefly, indeed, it has been watered down from to do no harm, which is very ambitious, to do no harm at all, because the treaty talks about a high level of protection, not the highest level of protection. So does your thesis provide arguments that the ambition of the principle of prevention should be more than only to do no significant harm?
Yes, absolutely. However, I am not suggesting with my thesis that we should suggest an absolute prohibition of pollution, because that will not, in my opinion, be feasible. What I am suggesting, to solve this possible short circuit, I think we could consider prevention as minimization to full possible extent. However, I think that prevention, of course, should not be intended as an absolute prohibition, but as a rule that should be followed by the administration in its discretion, which, of course, is subject to the principle of legality, to then be able, of course, to assess other interests that might be available in the environmental decision-making process. For example, I remember the IED review most recently, where, for example, cattle were excluded from the IED review. And that, for example, for me, was something that could be used through the principle of prevention.
Thank you, Mr. Maletto. The opposition will be continued by Professor Eli Antonio. Professor Eli Antonio is Professor of European and Comparative Administrative Law and Procedure at our university. Professor Antonio.
Thank you. Thank you, Mr. Chairman. Dear candidates, first of all, also from my side, congratulations for your doctoral thesis, which is well written, well researched, and makes a compelling case for a greater role of the principle of prevention in international and EU environmental policy making. My question today, perhaps unsurprisingly, concerns the EU chapter of your thesis, and even more unsurprisingly, perhaps, the role of the Court of Justice of the European Union in its use of the principle of prevention. It is in fact a two-pronged question. So here's the first part of my question. From reading chapter 5, I could not completely understand whether you argue that in the eyes of the Court of Justice, the principle of prevention is per se not justiciable, so it cannot be an actual actionable parameter of legality of the EU action or inaction, or whether you argue that the principle is actually justiciable but would only lead to the annulment of the EU action in cases of very manifest errors made by the EU authorities. So I would like, first of all, to ask you for a clarification in this respect. Now the second part of the question, which is not so much about the current stance of the CJEU on the principle of prevention, but more normatively on what you deem ought to be the position of the court. And if I interpret your position correctly, still in chapter 5, it seems to me that you are advocating for a very strong, or in any case stronger, role of the Court of Justice in the enforcement of the principle of prevention, even going beyond the threshold of manifest error of assessment, which is the usual threshold employed by the Court of Justice in complex technical assessments these days. It could, however, be considered, and that there comes my question, that a more intense review by the court of the very largely discretionary choices of the EU legislators and also of the EU administration, the Commission mostly, would be problematic from the perspective of institutional balance, separation of powers, if you wish. So I'm wondering what would be then your counter-argument in this respect.
Thank you.
Hi, esteemed opponent. Thank you very much for this question, which I think is very interesting, and it's something I was reflecting so much while preparing the defense, because I think it's an aspect, especially the second question, on which there is room for further study and research, because it's not much expanded in my book. So, with regard to the first part of the question, the position of the Court of Justice of the European Union has changed through the years. It started while considering the principle enshrined in Article 191, paragraph 2, as indeed actionable. Then later, the Court of Justice changed its interpretation and considered that the principle of prevention, as included in the treaties, is not something on which every measure adopted by the EU should be based on, but as a sort of general policy guideline that should be followed, and then can be scrutinized and as actionable only in cases of manifest error or something systemic that to date I have not been able to find in the jurisprudence of the Court of Justice, which also I must say is quite little on the principle of prevention. There is not much about it compared to other principles, such as, for example, the principle of precaution, and that again leads us to think again on the importance of academic research to bring impetus on certain topics. So this is the answer to the first question. With regard to the second one, I definitely would advocate for a stronger role of the principle of prevention at EU level. Of course, the legal order of the EU is a bit complex in this way, because in the end, of course, the European Union is bound to follow public international law in its action. However, public international law, as we know, does not enter the relation between the Union and the states. So it will basically something that the EU will need to follow the principle of prevention as it is in the international legal order in the enactment of its legislation. However, its action, for example, could not be scrutinized, could only be scrutinized in limited numbers of procedures. For example, it doesn't enter infringement procedures, which of course are crucial to assess then the behavior of member states with the EU law. In my opinion, I think it's a very interesting topic, the approach to discretion, because in a way I am not suggesting that we limit excessively the discretion, for example, of authorities exercising their administrative powers in the principle of prevention. Of course, as I said before, they're always subject to the principle of legality, and so they are bound to follow the principle of prevention. However, there is also I'm not suggesting then, also in the pathology phase, that judges become decision makers. That's something that would basically make them overstep their powers and invade other spheres of the division of powers. In my opinion, this is an extremely relevant topic, which triggers problematic considerations between a balance between the necessity, of course, to always ensure full jurisdiction, and on the other hand, for judges to respect the functional limits of their jurisdictions, also in relation to their approach to science, which is often treated as almost as a dogma by judges, also lately by the heat laws, which ex abrupto referred to the reports of the IPCC as the best available science without any further consideration. And so I think that also triggers considerations related to for example, on the one hand, how science is acquired by tribunals, for example, the role of experts, and on the other hand, the importance of environmental democracy rights, and to make sure, for example, that the scientific evaluations that are enshrined in relevant instruments are also accompanied by guarantees in terms of participation that can, of course, add input and guide, again, the discretion of the administration. The discretion of the administration is a process which is complex and requires different inputs in order to guide how the administration has to pursue the public interest, always with the limit of the principle of prevention as a binding rule on the administration. Thank you.
Thank you. The opposition will be continued by Professor Fitzmaurice, Professor Fitzmaurice is Professor of European and Comparative is Professor of Public International Law at Queen Mary University of London, and I welcome you very much to Maastricht.
Thank you very much. Thank you very much. I appreciate a lot to be asked to participate in this very interesting PhD procedure. I really enjoyed reading your book and your presentation today. Very interesting. I would like to ask my questions, which relate also to my personal interest in theoretical and practical problems of principles of international environmental law. And this topic especially gained importance with the International Law Commission undertaken the topic of general principles of law. And as we know, the special rapporteur in one of his reports really even dealt with principles of foundational principles of international environmental law. So my question, which will relate to principle of prevention and the precautionary principle. So the question is as follows. Are the legal contours, the content, and the practical application of the principle of prevention and the precautionary principle exactly the same in global and regional environmental agreements, especially including the land-based pollution? Thank you very much for your attention.
Highly esteemed opponent, thank you very much for your question, which I think is very important, because in the end, the principle of prevention and the precautionary principle are complementary principles that do apply together and in a always strong, I think, combination. In my research, I chose not to focus too much on the precautionary principle, because otherwise it would have opened a completely new line of research. I do, however, think that the issue of how these principles compenetrate and operate among each other is crucial. In the end, my conclusion is that the principle of prevention, as we know, operates with regard to non-risks to the marine environment in our case, while the precautionary principles very much relate to scientific uncertainty, and so as also clarified in the 1992 Rio Declaration, is crucial not to postpone environmental action when it should be required at a very at an earlier moment. And I think their compenetration is crucial because, also in relation to the role of science, the best available science is a topic that I have discussed very much in the thesis, also because of its potential in integrating the due diligence standard that states are required to comply with while complying with the principle of prevention. And of course, an advancing in science is crucial to, in a way, retract the moment of application of the principle of prevention and trigger precaution and trigger the application of the principle of prevention that comes when science is certain, is known, and requires environmental action to be taken to comply with this rule of general international law. I hope I've answered to your question.
Thank you. And then the opposition will be continued by Professor Ragni. Professor Ragni is Professor of International Law at the Università degli Studi di Milano, and I welcome you very much to Maastricht University. It's an honor to have you here.
Thank you very much. It is my pleasure and my honor to be here. And I would first like to congratulate with the candidate for this very precise and impressive research. Well, I have a question relating to the content of the principle of prevention, which is somehow connected with the question of Professor Fitzmaurice. Well, in chapter 4, you seem to argue that specific obligations deriving from both bilateral or multilateral treaties dealing with land-based, with pollution from land-based sources are a sort of specification of the principle of prevention. So my question, well, I did not really understand whether your conclusion is that once a state complies with these specific obligations deriving from these treaties, this is sufficient to satisfy the obligation to prevent pollution, as, for example, provided by the UNCLOS, a conclusion, this one that the ITLOS put into discussion in the advisory opinion of 2024 that you took into consideration. So I would like to know what is your position in this regard, or whether you think that the principle of pollution implies different obligation than those provided by specific treaties, and if states are required to do something more than just complying with that treaties. Thank you.
Highly esteemed opponent, thank you very much for your question, which again I think it's very very important and triggers very relevant considerations. Of course, in order to practically apply the principle of prevention, the only choice it could be followed in my opinion was to assess what are acting the principle of prevention and its implied rule to prevent marine pollution from land-based sources was actually to try to investigate the standard of due diligence that characterizes this rule, and that was quite a difficult task, because we are, as you said, assisting to a proliferation of multilateral environmental agreements with a vast amount of rules regulating the issue. So it's quite important to clearly reconstruct the content of this rule and of this rule, and of course of the due diligence that characterizes the rule. In my opinion, of course, as acting the principle of prevention as a framework rule, the same by its nature operates by discharging compliance with sub-obligations, so with different rules that can be retrieved from the applicable legal framework. So my question is that my answer is that of course you have to rely on the obligations that you can in the end retrieve from the available applicable framework to states. On the other hand, as we know, the principle of prevention operating as a due diligence rule also includes a very relevant dimension of the role of science, which integrates again the rules. So again, states are not only to require, for example, to comply with their environmental impact assessment procedures or authorizing discharges, etc., but also to assess the best available science in the sector that persistently and continuously integrates the rules. So indeed, apart from a formal compliance with specific sub-obligation, there should be, I think, also a continuous effort by states to adhere to a growing and always evolving standards of technology and scientific knowledge, and that again, I think, also brings us to the importance and delicacy of the role of science in a way, because of course scientists are not policymakers, and it's something that we should be very much careful with. And in this regard, I think that this makes me think again on the importance, for example, of all the soft law production that is accompanied that stems from environmental treaty regimes that in a way orient states on how to comply with obligations that for legal certainty of course should remain solid and steady, but on the other hand we have this production of work that orients states in how to comply with these obligations. However, I always think that it's always important that these instruments are, as I was saying before, characterized by public participation, by diversified inputs, and are also transparent and accountable. That brings also again to the importance of combining rules of public international law with rules of administrative law in the end, because it is then the practical application of an international rule then is borne by public administrations, which in exercising that their powers. So I think there is of course a combination of interest and with regard to the ITLOS, I think the ITLOS might have been in a way a bit optimistic in this sense, because it's quite straightforward in referring to best available science, the rules and standards available in the sector, without exploring, I think, that much these issues. But of course, the input of the ITLOS, I think, is crucial, because in the end, in its advisory opinion, the aim in the end is furthering these obligations of public international law, and probably it could be a bit aspirational, but I think it's crucial in any case. Thank you.
Thank you very much. So your conclusion, if I may, is that it is not sufficient for a state to comply with the specific obligations in order to satisfy the duties deriving from the principle of prevention, because there are further obligations that are also procedural in nature, like the one of taking into account the best available science, or to take into account also the opinion of the public. So thank you very much for this clarification.
Thank you. Then the opposition will be continued by Professor Schuite. Professor Schuite was, as well as Professor Fitzmaurice and Professor Ragni, member of the Assessment Committee, and Professor Schuite is Professor of Environmental and Government Liability Law at Maastricht University. Professor Schuite.
Thank you, Mr. Prorector. Dear Mr. Candidate, first I would like to compliment you on an innovative dissertation. The protection and preservation of the marine environment is not only at the political and societal forefront, but also in legal scholarship. Your research contributes to a specific part of the subject of environment protection, but it is a very important one, the protection of the marine environment. Furthermore, I would like to compliment you on the way in which you improved the methodology after the feedback of the manuscript committee. Of course, and perhaps unfortunately from where you are standing, we are not only here to provide compliments, we are here to engage in a lively academic discussion. I have two questions I would like to ask, a methodological one and a more substantive one, and I'm going to start with my substantive question. Maybe there will be room left for the methodological question. In your thesis, you examine whether the current legal framework addressing marine pollution from land-based sources is effective. At the end of part 1, you reach the conclusion that the current framework is, in my own words, not effective enough. The global framework has little to no normative force, the multilateral agreements lack enforcement power, and the EU framework lacks overall coherence, so you argue. To effectively tackle the problem of marine pollution, you extract common elements of these three frameworks and formulate a general normative and enforceable rule, being the rule of prevention. Put differently, you stay within the context of the existing legal framework. My question is whether you also explored more, so to speak, out-of-the-box ideas. I'm going to share with you an idea, a thought, if you will, and I would like you to reflect on this thought. In 2017, the Whanganui River in New Zealand, excuse my expression, became the first river in the world declared as its own legal entity. Since then, guardians of the river, this can be a foundation or a board, are able to exercise the river's rights. If, for instance, a party harms the river's well-being, the guardians can sue these parties. The idea of a nature body being a legal entity might sound strange at first, but legally it does not really differ from what we have been doing to companies for decades now. Today, more and more nature bodies are declared as legal entities, and Dutch government is even investigating the possibility to declare the Waddenzee, and mind you, this is a marine environment, as a legal entity. The main advantage of recognizing a nature body as a legal entity is that we see this entity as an independent and equal legal person. It has its own rights and is protected not because we enact all sorts of treaties and regulations top-down, but because we recognize the intrinsic value of the nature body. Have you thought of protecting marine environments in this way? Do you perhaps see strengths or weaknesses in the idea of marine environments being their own legal entity? I'm very curious.
Highly esteemed opponent, thank you very much for this question, which I think is very timely because we're hearing a lot about this topic of rights of nature, something very new. There is a lot of talk about it, and I agree. It's a very interesting topic that is somehow a bit far from our legal experience at least in the European Union, which is very much anthropocentric in a way, and still presents very significant elements of lack of implementation and enforcement. So it is definitely something new and that deserves relevant exploration. However, in the end, it depends again on, unfortunately, I might say, on the implementation in the end of entities as we know them, of traditional law. Because I refer, for example, of an example in Europe, which is the Mar Menor lagoon in southern Spain, which is a lagoon that is affected by a very serious phenomenon of eutrophication that led basically to the death of the ecosystems in the area. And there also it was presented a solution in the sense of the rights of nature by endowing the lagoon with legal personality. However, then there is always a persistent problem that arises, which is the implementation by administrative authorities of all the instruments that allow these solutions to actually work. What I think is very interesting with regard to this is that in the end, in the international legal order, we could say that there is a way by which the marine environment already has a sort of legal personality, a legal entity, because I am describing the obligation to prevent marine pollution from land-based sources as a rule of customary law, which has an erga omnes character of application. We are not only due to the features of marine pollution, but to the growing interest in considering the marine environment as a global common good of mankind. The fact that an erga omnes rule allows every state to react to a violation of the principle of prevention somehow already implements very primitively maybe this idea. The problem that I see is that there is always the necessity of some human reaction needed. In this case, we would need a state to react to a violation. However, in this case, the state would react not for a violation of its sovereignty or of the principle of good moralness or other principles, but as the holder of the interest in the respect of the integrity of the marine environment in line with Article 192 of the UNCLOS. So I think, in a way, this way of operation of this rule could be considered as some sort of right of nature, in my opinion. But yeah, I think it is indeed very interesting, and I think that we should research probably more on how these rights of nature are to be implemented, because in the end, at least in the European Union, we have very powerful instruments. I think, for example, the Habitats Directive, in my opinion, has huge potential in terms of application, but we see persistent implementation and enforcement deficits that could be supplied through more ambitious enforcement actions. So I think there are plenty of solutions, and all of them deserving to be further explored. Thank you.
Thank you.
Thank you. Then the opposition will be continued by Professor Bouharinen. Professor Bouharinen is Assistant Professor of EU Environmental Law at Maastricht University. The floor is yours.
Thank you, Chair, and also my warmest congratulations for the candidate for this thesis that addresses one of the most crucial issues I think we have at hand at the moment, the status of our seas and ocean. I would actually want to focus my question on the more theoretical background of conceptualizing effectiveness of law in this thesis. Effectiveness of law basically refers to the impact that the law has on the ground, for example, in the environmental condition. And as such, it's thoroughly researched concepts where usually the perspective invite more multidisciplinary theoretical setting. For example, these theories may range from political theory, social sciences, environmental economics, and governance theories that are then used to explain effectiveness and frame the legal analysis. The thesis makes the argument that enhancing the application and role of the principle of prevention would contribute to improving the effectiveness of the legal regime in addressing this environmental problem. However, I find that maybe the concept of effectiveness remains a bit undefined, and also the theoretical justification for offering the principle as a solution could use a bit more positioning. So I want to ask you, what is the theoretical positioning for the conception of effectiveness in this thesis that justifies the conclusion that a legal principle, enhancing the role of legal principle, would have such an effect in the real world effectiveness of the law? Thank you.
Highly esteemed opponent, thank you very much for your question, which, to be honest, I very much agree with. I think it's a point that could have been explored a bit more in the research. It's something that, under a methodological standpoint, I had not expanded much, and so I completely agree with you, and I will try to reflect on it now. In my opinion, the concept of effectiveness is of course a very complex concept to investigate. If we start from the scientific data and from the situation of our seas, we might start from the assumption that the legal framework now is not effective, and it's not effective because otherwise we wouldn't have a problem that affects 80% of total marine pollution as such. Coming more to strictly legal arguments, I will start by saying that, in my opinion, effectiveness can be defined as a mix of three elements. I would say clear requirements, clear policy and legal requirements, effective monitoring to check if these requirements are complied with, and third, effective enforcement in case the legal framework is not complied with. And in this respect, what I have concluded following my analysis is that combining the relevant layers that I have examined in the legal framework, we cannot come to such conclusions because requirements are not clear. There are not. We cannot identify effective monitoring systems to verify if general, broad, and not coherent rule have been complied with. And finally, I noticed a very serious lack of enforcement remedies, and that, I would say, at all levels. If we start from the international legal order, we see how states are quite reluctant in acting in court against one another, also in relation to judicial instances that rely on the concept of the very states that submit to the relevant jurisdiction. Regional regimes, I think, are a very good example of scientific cooperation. They really work well. I think probably on the first two elements of effectiveness. The requirements are quite clear. There is scientific activities around monitoring, identifying priorities and strategies that could be working. However, in terms of effectiveness, the powers granted to treaty commissions, for example, are a clear example of how they have significant shortcomings in terms of enforcement actions. And then the European Union has a very powerful instrument, which is the infringement procedures. But as we see lately, the Commission is refraining quite much to engage in infringement procedure. The von der Leyen Commission is, I think, the one with the lowest number of infringement procedures started. So that also is probably can be reconnected to a lack of political ambition. In this sense, and so that's why what led me in a way then to rely to national remedies. We have jurisdictions. I refer to the Italian jurisdiction because it's the one I know best, which has, I think, a very critical potential to implement this effectiveness. If we think, for example, that the rule would have constitutional value, could be used to act to start environmental litigation to challenge a permit, for example, and that again I think will rely on the very relevant role of environmental NGOs, for example, and their standing in bringing litigation in environmental matters. Thank you.
Yeah, if I may, to just sum up real quick, if I understand correctly, then effectiveness in this thesis is a very legal concept and relates especially to the enforcement and operates mainly in the world of law, as per se. But maybe I would add that also effectiveness has to do with the problem-solving capacity of the law, where you maybe have to reflect legal designs a bit more with interdisciplinary background as such. But I welcome your positioning to remain at the enforcement and the legal side of effectiveness.
Thank you.
Thank you. Then the opposition will be continued by Professor Schuiter for his second question.
My second question is a short methodological question on the intermezzo part of the thesis, maybe even a question of structure. It is only at the beginning of the intermezzo, which is on page 149, that you really highlight the problem that pollution from land-based sources generates on the marine environment. I think the reason is that you want to show that despite the existing legal framework, the marine environment still faces a big problem, thereby proving the shortcomings of the existing legal framework. However, it confuses the reader a bit, who at the beginning of the thesis does not have a full and clear grasp of the problem, of the scope of the problem, and thus finds it sometimes difficult to follow the reason for the research. In the beginning, you do mention all kinds of facts about marine pollution, but they are less compelling than the part in the interlude, in the intermezzo. What was the reason for this choice?
Thank you very much for this question. Yes, I agree. It was the reason I think behind this choice was basically that before delving into the factual issues of the problem, I really wanted to have a clear grasp of what was the legal situation, and the reconstruction of the legal framework, in my view, was the first step to basically understand the problem under a legal standpoint, and then explore it scientifically. I agree that it could have been done at the opposite side, but I noticed that a comprehensive reconstruction was missing.
You are allowed to finish your answer, please.
That a comprehensive reconstruction of the legal framework was missing in literature, and that struck me actually, given the entity of the problem. So this is why I started from that. I tried to reconstruct what I had in my hands, and then tried to reflect on the problems that it implied. Thank you.
Thank you. Mr. Maletto, the time set for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return in this room.
Please all rise. The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Southside, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. The line, I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. The mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. Better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you've won the battle once you've grown. Southside, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goals only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile.
Mr. Maletto, the degree committee here present has assessed the quality of your thesis and of your defense. And in view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Faure is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I invite your supervisor to take the floor.
Please all rise.
Do you promise to work in accordance with the principles of scientific integrity at all times? To be careful and honest, transparent, independent and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Francesco Maletto, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university. Dr. Maletto, dear Francesco, it is a great pleasure for me to have the opportunity to call you Dr. Maletto and to congratulate you on this achievement. You came to me in the middle of the COVID times, like a little present that we could all well use in that difficult period. In April 2020, out of the blue, I received a mail from you showing your interest to do a PhD research as an external PhD student. At that moment, the topic you suggested was still relatively broad and focused on the polluter pays principle. And you wanted to look at regional European experiences and its role in addressing pollution from land-based sources of contamination. We started corresponding via email as I had some doubts on your focus on the polluter pays principle, more particularly in relation to the international conventions. At some moment, we were pointed at the fact that in Maastricht, officially we always need a second supervisor, and that gave me the great pleasure of collaborating together with Professor Francesca de Vitor from the Università Cattolica del Sacro Cuore, who you introduced to me. You started working and produced already in December 2020 a first 63-page chapter on land-based pollution in international law, focusing on the international legal framework. And a few months later, April 2021, you provided a similarly impressive, almost 30 pages overview of agreements on marine protection in Europe. What was still missing after this impressive positive legal analysis was a critical perspective, a normative view, or, if you want, a theoretical framework. In December 2021, you were still looking for such a theoretical framework within the polluter pays principle. But then we had, as we had all learned during COVID, various Zoom meetings with Francesca, and in January 2022, you saw the light. And you wrote us that you would now make a change, and it would make more sense to analyze the entire legal framework from the principle of prevention. And with that, the entire structure of the thesis, both the descriptive contents, theoretical framework, as well as the analysis, became much more coherent. After only having met many times virtually, Francesca was so kind to invite me to the beautiful city of Milano in April 2022, which I visited together with my two sons, where we were invited to a wonderful dinner with you and Francesca. I also had the pleasure, there was a price to pay, as always in life, to give a lecture at the seminar, which incidentally took place on my birthday. But I was fortunately able to hide that from you. And what is a better way, in fact, for an academic to celebrate its birthday than by presenting his research in a nice Italian environment to critical and inspiring colleagues. After that, things went quick, and the entire draft of the dissertation was ready almost a year ago, in autumn 2023. Your thesis is the first analysis of both international as well as a European legal framework focusing on land-based marine pollution. You also show how the principle of prevention could be used as a normative tool, both at the international as well as at the European level and at the domestic level, arguing that there is a renewed potential for this principle in the fight against land-based pollution. Now, given the scope of land-based pollution today, we only need to think about the problem that we all know as the plastic soup. It is not difficult to argue that your thesis is both academically as well as socially extremely relevant. Dear Francesco, in your first mail that you wrote to me on the 3rd of April 2022, you marketed yourself almost like an American. In a good Italian manner, writing inter alia, I start quoting. I graduated magna cum laude in 2016 from the Catholic University Law School with an international law-oriented curriculum and a final thesis. And then, right after graduating, in light of my interest in environmental law, I started to work as an associate in the environmental law department of a large Italian law firm. I qualified as a lawyer before the courts of Milan. In the perspective of continuing my education alongside my professional activities, I became acquainted with the possibilities to participate in a PhD program in Maastricht University as an external PhD student. I understand that before applying to the PhD program, it is necessary to make contact with a possible supervisor for the research. Thus, considering your huge experience in the field, with particular attention to the subject, I would be thrilled to delve into. I deemed appropriate to contact you in order to verify whether you would be available to act as a supervisor for my research. You understand, dear Francesco, after having received such a nice and flattering email, which was also accompanied with an impressive CV, I could do nothing else than to accept this kind proposal. And I do think that you understand that today, 4 years later, I am very happy that I took in April 2020 this flattering email seriously. You see, at least some good things originated from the COVID period. Dr. Maletto, dear Francesco, it has really been a pleasure for Francesca and for myself to work intensively with you during the past 4 years. You have done this research together with a full-time job as a lawyer at Client Earth. Thereby, it should be mentioned that you completely performed this research in your own time and that Client Earth had nothing to do with your research, neither by financing or contents-wise. Now, it is amazing that you have been able to come to this achievement in addition to a full-time job within 4 years through hard and good dedicated work. You are in that sense really an example to many others. Now, your other supervisor, Francesca, has to appear before the Grand Chamber of the court in Strasbourg. Fortunately, you know, in Strasbourg there are no individual suspects who appear, but she appears as an expert in Strasbourg, and therefore she only participates online, but she has been adding to this laudatio as follows. Until the last moment, she tried to jungle with train timetables to be here in person, to share with all of us, but especially with you, this exciting moment. Being unable to manage it, she asked me to tell you that she knows that during these 4 years of interminable meetings, you probably hated her, returning again and again to the same international law issues. Those are her words and not mine. Being an old-style Italian legal positivist, always coming back to the contents of customary law, more than to the general principles. Nevertheless, she asked me to tell you how much she enjoyed those many hours in which she appreciated your willingness to improve your work to the best, despite the difficulties of doing so in the free time in addition to your full-time work. And above all, she really appreciated your capacity to face difficulties, being always kind, always smiling. For that too, you are an example. She really hopes that you will continue the many conversations with her, now as friends and as colleagues, because she adds, if you would not, she would really miss you. So, it is also on behalf of Francesca that I thank you very much for the 4 years of pleasant and fruitful collaboration, and on behalf of both of us, I congratulate you wholeheartedly on your achievement, wishing you lots of luck in your professional and private life.
Thank you, Professor Faure and Professor De Vitor. Thank you very much. Dear Dr. Maletto, also on behalf of Maastricht University, I warmly congratulate you on the degree you have just acquired. And my congratulations go also to your family and friends. Before I close this ceremony, I'll have to invite you to taking a photo. And we'll take one in front of the screen, and then we'll take also one on the stairs of this monumental building. Having said this, I close this academic session.